Hello, everyone, or should I say Gamar Jobat? It's really nice to be here and to present to you. Um, my presentation really dovetails on the presentation that was given earlier by our friend Anis from 500 Startups, who really very ably described why you should go to the US, when you should go to the US, when it's not such a good idea to go to the US. So we probably are more or less clear on that. So in my presentation, I will focus on legal aspects of doing business in the US, of going to the US in a corporate entity, as a corporate entity, fundraising there, and so on and so forth. A couple words about me, just to give you an idea of where do I come from when I give these comments to you. I'm a Russian qualified and US qualified attorney with 20 plus years of experience in international mergers and acquisitions and venture capital. I work for an international law firm, Rimon. Before that, I worked for other major law firms, most recently Oric, which is one of the leading firms in the VC space. And at Rimon, we have pretty much, our offices in all major hubs, in all major technical hubs. So we cover all aspects of startup life. We represent dozens and dozens of startups every year. We also represent venture capital firms and growth PE firms, private equity firms that are active in this space. I, for example, represent Fort Ross, a major VC firm for Sberbank, who you probably all know. They invest very heavily in US and Israeli startups. And so that's my background. I deal with these issues a lot, and I want to summarize some of the thoughts on legal side that I often see when dealing with startups going to the US and from US going globally. So there you go. You're launching your startup, you're launching your venture, and I really like this analogy of a spaceship, really, that tries to take off from the Earth and go to stratosphere and above, to the orbit, and it takes a lot of energy from the founders, as you all know. But it also takes precision, because you really have to calculate very carefully where you want to end up. You want to end up on the orbit where you're aiming, and not, sort of being a brick and fall down and never take off. And my overall advice to startups that I work with is twofold. And if you take out just one thing from this entire presentation, that should be it. One thing is focus on IP protection, because IP is really, really important, and that's sort of the focus of due diligence of your angel investors, and more so of your investors going further. But secondly, on the legal side, do everything in a very, very standard way. And this may sound a little counterintuitive, because you obviously are inventing new products, you're breaking into new markets, you're doing things differently. But on the legal side, I would strongly suggest that you be as standard as possible. Because you want to be creative in your product, you want to be creative in how you approach business, but you should do things in the way that your VC investors are used to seeing. You should do things as all investors expect them to be. so that they really focus on your product and on you rather than on why you set up this structure this way and why is it this way, and these are not the kind of questions that you want to get from your investors. So be very standard in that, and get a lawyer. Obviously, get a lawyer who knows this space, because not every lawyer can deal with startups, with VC rounds, with all other aspects of this work. It really has to be someone who is in that business and does this day in and day out. So what we'll focus on really briefly is why you set up a US company, how you do this, what shares of stock you have, and what types of financing you should be aiming to get, and how to get it in the US. Starting from the very beginning is setting up a US company. Why you should set up a US company? First of all, because if you want to do business in the US, it's much easier to do this with a US entity. Secondly, if you are aiming to get US funding from US VC funds, you definitely need a US entity. US investors very, very rarely invest in any companies other than US companies. So you definitely need that. And obviously benefits are well known of being in the US. You get access to this huge market, to this huge funding pool, to startup communities that are not available in some of the countries. And you have access to exit markets that are not available in many developing countries or less developed countries. So how do you go about setting up a US company? First of all, what company do you need? You need, if you are a startup, a technology startup that wants to go after VC money and wants to scale big time and become potentially unicorn, you definitely need to set yourself up as a Delaware C corporation. And I listen to arguments of some of the folks in our space and hear them saying that you need to be in Wyoming, for example, or you need to be in Nevada for tax reasons. Predominant view of US VC community that you should be Delaware C corporation. So it would be very, very unusual if you go elsewhere. You will have to explain. You'll need to do a lot of explaining why you did that, and eventually you probably will need to flip to Delaware anyway. So why Delaware? Because everyone does this, and this is in itself a big factor, because if everyone does this, you just follow the crowd, and you just don't raise any issues by doing the same thing. VCs are very familiar with Delaware law. Also, US lawyers, all US lawyers are very familiar with Delaware law, and this is important because every lawyer in the US he has to be qualified in a particular state. So I'm, for example, qualified in New York. A lot of folks in this space are qualified in California, but all of us will be very familiar with Delaware law. So, for example, issuing a legal opinion in the context of your Series A, Series B round will not be an issue. And if you're in another state, it will be more expensive and just more difficult for everyone, really. And you don't need to have an office in Delaware, and you can benefit from filing everything electronically and doing really everything really expeditiously. How do you establish a company? You can do this yourself, including electronically by just going to clarkey.com, the Stripe, some other service providers that help establish that, and you just register your company. It's that easy. You don't need to live in the US. You don't need to be a US resident or anything of that sort. You don't need to have US directors. But if you have some substance to your startup, if you're really sort of beyond just the idea stage, and you really have some IP in your startup, it's really strongly recommended to go to a lawyer and get some help with establishing a company. It's not about just registering a company. It's really about forming a company with all things that we will very briefly touch on in a second. If you already have a company in your country, such as Georgia, Armenia, Turkey, you may need to do a flip, and this is just a part of terminology that you need to be aware of. And this is basically a transaction that establishes your US company, and the US company does a share swap with your local company, so that the local company becomes a 100% subsidiary of the US holding company, and all your shareholders' relations are at the US level. This is a little bit more sophisticated a transaction, so you really need a good lawyer for that. But that's what you often have to do if you go to US market, if you approach VCs in the US, if you go to US accelerator. That's what they expect you to do. In terms of setting up the company, these are the kind of documents that you will have as part of your company formation process. And obviously, a lawyer who is establishing your company will do all these things. So it's not just corporate documents. It's also employee offer letters, consulting agreements, confidential information, invention assignment agreements, all documents that you need basically to start in the US. You also need to be aware that there are very important filings that you will have to make, and it's very important not to miss them, because some of them may end up, getting you in trouble, and may end up with some fines. I just want to highlight one of the documents, and that's 83B election form. This is filed with the IRS, with the Internal Revenue Service in the US, and very often the founders really miss that, and they don't file this form in time. And there's very short period of time when you can do this, probably like 30 days after establishing a company. If you don't do that, you may end up with very big tax liability when your shares come out from vesting and you don't have any cash, but you have a liability to the IRS to pay some taxes. So it's very important not to miss these forms, particularly 83B. When you establish a company, you issue stock to founders, and that's a common stock. It's important to distinguish that from preferred stock that you will issue to your investors. Normally, you authorize 10 million shares when you establish a company, and that's that may sound like a lot. Why do I need that? And there are reasons for doing this. I can answer questions if. But that's what you do basically. And then when you do priced rounds, when you do Series A, Series B, you issue preferred stock to investors, which is different from your common stock. It's different in terms of rights and preferences that are given under those shares. There are also some concepts that you may not be aware of if you establish a company via Clarkey or Stripe, or just do it yourself. For example, founders preferred stock. And founders preferred stock, this is a relatively new concept that gives you an ability to really take some money to yourself as a founder when you do a priced round. Basically, normally you would issue all your preferred stock to your investors, and all this money goes into your company, not to you as a founder. But it's possible to establish right from the beginning, and you can do this only at the very setup of your company, to issue yourself as a founder some founders preferred stock that you can actually sell in a context of a round and get some cash out, which is very helpful to many of the founders at an early stage. And employees obviously get common stock just as founders do. Very important concept to keep in mind is vesting, and sometimes it's also counterintuitive. Why would you do that? Essentially, vesting is a concept that allows your company to buy out your stock at nominal price in certain situations. So basically, you, for example, you're a founder and you have 1/3 of common stock of the company, but most often this stock will be subject to vesting. So for a period, for example, of 4 years, some of this stock can be repurchased by the company at nominal value, so that you end up with less shares if you leave the company. And there are a lot of details, and I can explain if there are any questions. But it's just important to keep in mind that this is a concept that is both in the interest of the investor, because investors obviously want to have all folks in the team, in the founders team, all really doing the project for a decent period of time until it becomes self-sufficient. But it's also very helpful from your perspective as individual founders, because you also want to tie your fellow founders to your startup and not have them look elsewhere and not contribute to your venture. And then once you establish a company, you raise money. And the important thing in raising money in the US, and this is actually one of the helpful things why a lot of startups who are not even doing business in the US yet want to have a Delaware C Corp, is because you can raise money from a huge pool of investors, but also raise money on very beneficial terms. And these terms, obviously, they include commercial terms, but they also include legal terms, because in the US, you can attract financing under very standard documents, such as SAFE, Simple Agreement for Future Equity, or convertible notes. And we'll go into some details of those instruments in a moment. And why would you do that? You do that because issuing preferred shares that we spoke about a little earlier is very expensive. It's legal fees for lawyers on the investor side, for your lawyers, but it also is a priced round, meaning that you have to have a clear valuation of your company to issue this stock. And at early stages, you don't have that. You don't have valuation. You don't know. You can't agree with your early investors on how this company should be valued. So it's very important to be able to raise money without this complications of a priced round of valuation of this comprehensive suite of investment documents. And there are a lot of documents that are involved in the Series A offering. So what you do at early stage is you issue SAFEs, simple agreement for future equity, or convertible notes. And I hope investors at this conference are not listening right now, so it's just for the founders. SAFEs are really more beneficial for the founders. Convertible notes are more beneficial for investors, and they know that. But SAFEs also offer ability, since this is a very standard document, to do a deal very quickly. So very often you are able to convince your investors to do this under a SAFE, because legal fees are minuscule. To do a SAFE, basically all you need is agree on discount or valuation cap, and you're good to go. You don't need to negotiate dozens and dozens of terms. Investors prefer convertible notes, and that's understandable. They are more complicated. There are more sort of different types of convertible notes that you need to deal with. Now, a larger variety of forms. They are also a debt on your company, and you don't want that, ideally. You don't want to have this risk of essentially going into default in a year or a couple of years when this convertible note matures, and you really need to renegotiate with your investor, some extension. So you do a SAFE, and there are for the forms of the SAFE. You go to a website of Y Combinator, and they're all there. They're very standard for everyone to see, and there are several types: cap, no discount; discount, no cap; cap and discount. You just pick a form that suits your needs, and do a deal in one day, and that's how a SAFE looks, and it's very, very convenient. Another point that I wanted to highlight is it's very important to keep an eye on your dilution. You issue SAFEs, you issue convertible notes. You think that you haven't really parted with a big chunk of your company yet, but when they convert into preferred stock, they actually can dilute you quite a bit. And an easy way to deal with this is really to get some automated help from apps like CapTable.io or Carta, and they allow you for either free or for very, very little money. They allow you to keep an eye on how you dilute yourself, issuing each SAFE, each convertible note. You can model basically your Series A round and negotiate with your investors, knowing all that background, which is very, very helpful. The last point that I wanted to highlight, because we don't have much time and I want to take some of your questions, is outsourcing fundraising, because this is something that I see a lot. It's very appealing to founders to basically have someone else deal with fundraising, because you focus on your product, you focus on your customers, you focus on your market, you do that, and this is hard enough. You don't want to have like a second job essentially, which requires completely different set of skills to do fundraising. But most important takeaway is really that most efficient, most reliable fundraising is really done by founders themselves. There is no substitute for networking, for establishing long-term relations with VC investors. And there are some legal issues in addition to just efficiency and VCs wanting to deal with founders directly, because there are some SEC and other legal rules that may apply here and that may potentially create a risk of your issuance being under legal challenge from the SEC, from the Securities and Exchange Commission of the U.S. If there is a broker, for example, without a broker license, and that most of these intermediaries that offer these services, they don't have broker licenses. So just be very careful. Consult with your lawyer if you want to do that. And I see that we only have maybe like 3 minutes or so. So it would be really good to take some of your questions. But again, I am very open to taking your questions offline. Just write me an email or shoot me a message in any of the messengers. Thank you.